Hi, my name is Nicole Clark. I'm an attorney in Prattville, Alabama, and I'm here to talk to you today about a piece of legislation known as the Children's Equal Access Act. Currently, when we are fighting for custody of a child, one parent wins primary custody and the other parent is a visitor. They get visitation. That's approximately 80 days a year. Sometimes it can be a little more or a little less. When a child doesn't have access to both parents, they experience more trauma throughout their life. Studies show that children who do not have equal access are more likely to be depressed, suffer from anxiety and stress. They're more likely to experience teen pregnancy. They're more likely to experience drug and alcohol abuse, and they're less likely to be able to maintain relationships when they're older. As the law currently is now, we are starting out in a very adversarial manner. So everybody's fighting for that primary custody. So my job as an attorney is to take every little detail you give me and turn it into a big deal. And that hurts our children in so many ways. Even if you don't discuss the issues with your child directly, they know what's going on. They can sense your stress. They can sense your anxiety. They can hear you talking about the other parent in the other room. Even if you think your kids are asleep, they can hear you. They know what's going on. And this just adds stress and anxiety to them as well. So this bill would kind of change our starting point. We would go from this adversarial fighting for this coveted position to a joint custody situation. This would take two fit parents and put them on an even playing field, where the child would have equal access to both of them. Now with this, we're talking about fit parents. So if the other parent is an alcoholic or has drug issues or a criminal history, a violent criminal history, then we wouldn't even apply this bill to them at all. This is only talking about fit parents. The Alabama Law Institute actually drafted this bill initially. ALFRA has worked with many other committees and has taken the Alabama Law Institute bill and inserted some additional language to this bill. They have defined joint custody, because I know many of you are thinking joint custody, I can't be away from my child that long, or joint custody equal time won't work because of the other parent's work schedule or where they live, but that's not accurate. Joint custody in this situation is defined as equal as possible time with both parents. So that may be a different visitation schedule than every other weekend, but it may not necessarily be week on, week off. This bill requires the parents to do a little more on the front end. One of the issues that I see a lot of times when parents come in, or when I'm representing a mom or a dad, a lot of the issue is communication. And then the other parent didn't meet their expectations. So this bill would require the parents each to submit their own parenting plan. And this would cut down on that expectation. Both parents would know exactly what their expectations are and how to communicate. So each parent would submit their own parenting plan. The judge then can look at these parenting plans. If they're not the same or if they're not close, the judge can pick one plan over the other, or combine the two plans, or scratch both of those plans and make his own plan, or her own plan. That is one thing that I really like about this bill, is the fact that it does require those parenting plans. Like I said, that cuts down on a lot of the confusion and frustration between the parents. And that, of course, benefits our children so much. One thing that I've heard a lot of negativity about this bill relates to domestic violence. A lot of people are concerned that if there's a perpetrator of domestic violence, then they should not have custody of their children or be that primary custodian. This bill does not change the existing law. Currently, the domestic violence statute states that if someone has been found to have committed acts of domestic violence, then there's a rebuttable presumption that they are unfit as a parent. So they should not have custody of their kid. This bill does not change that. It doesn't change or add or take away anything from that domestic violence statute. What it does do is now it creates a rebuttable presumption that both parents are fit unless the judge deems otherwise. And there are 16 different points in this bill or act that will allow the judge to deviate according to his discretion. One of those even says, he can add whatever other facts or circumstances he deems appropriate to deviate. It also requires the judges to lay out in their order why they deviated from this plan. So you'll know exactly why you didn't get access to your child or what the issues were. Overall, this is a great bill. It's a great act. I would love to see it passed as it's written. If you would like more information, please contact ALFRA or the Alabama Family Rights Association, or you can contact my law office, and I'd be happy to talk to you more about it.